We continue with Trump v. United States, picking up on page 9 with part 2 of the opinion. Section B. But of course, not all of the President's official acts fall within his conclusive and preclusive authority. As Justice Robert Jackson recognized in Youngstown, the President sometimes acts pursuant to an express or implied authorization of Congress, or in a zone of twilight where he and Congress may have concurrent authority. The reasons that justify the President's absolute immunity from criminal prosecution for acts within the scope of his exclusive authority therefore do not extend to conduct in areas where his authority is shared with Congress. We recognize that only a limited number of our prior decisions guide determination of the President's immunity in this context. That is because proceedings directly involving a president have been uncommon in our nation, and decisions of the court in this area have accordingly been rare and episodic. To resolve the matter, therefore, we look primarily to the framers' design of the presidency within the separation of powers. Our precedent on presidential immunity in the civil context, and our criminal cases where a president resisted prosecutorial demands for documents. The president occupies a unique position in the constitutional scheme, as the only person who alone composes a branch of government. The framers sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single, constitutionally indispensable individual the ultimate authority that in respect to the other branches the Constitution divides among many. They deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of the laws, the protection of property, and the security of liberty. The purpose of a vigorous and energetic executive, they thought, was to ensure good government, for a feeble executive implies a feeble execution of the government. The framers accordingly vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. He must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. There accordingly exists the greatest public interest in providing the president with the maximum ability to deal fearlessly and impartially with the duties of his office. Appreciating the unique risks to the effective functioning of government that arise when the president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, we have recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. In Nixon v. Fitzgerald, for instance, we recognized that as a functionally mandated incident of his unique office, a former president is entitled to absolute immunity from damages liability predicated on his official acts. That case involved a terminated Air Force employee who sued former President Richard Nixon for damages, alleging that Nixon approved an Air Force reorganization that wrongfully led to his firing. In holding that Nixon was immune from that suit, our dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision. The singular importance of the president's duties, implicating matters likely to arouse the most intense feelings, coupled with the sheer prominence of his office, heightens the prospect of private damages suits that would threaten such diversion. We therefore concluded that the President must be absolutely immune from damages liability for acts within the outer perimeter of his official responsibility. By contrast, when prosecutors have sought evidence from the President, we have consistently rejected presidential claims of absolute immunity. For instance, during the treason trial of former Vice President Aaron Burr, Chief Justice Marshall rejected President Thomas Jefferson's claim that the President could not be subjected to a subpoena. Marshall reasoned that the law does not discriminate between the President and a private citizen. Because a president does not stand exempt from the general provisions of the Constitution, including the Sixth Amendment's guarantee that those accused shall have compulsory process for obtaining witnesses for their defense, a subpoena could issue. Marshall acknowledged, however, the existence of a privilege to withhold certain official papers that ought not light ground to be forced into public view. And he noted that a court may not be required to proceed against the President as against an ordinary individual. Similarly, when a subpoena issued to President Nixon to produce certain tape recordings and documents relating to his conversations with aides and advisors, this court rejected his claim of absolute privilege, given the constitutional duty of the judicial branch to do justice in criminal prosecutions. But we simultaneously recognized the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making, as well as the need to protect communications between high government officials and those who advise and assist them in the performance of their manifold duties. Because the President's need for complete candor and objectivity from advisors calls for great deference from the courts, we held that a presumptive privilege protects presidential communications. That privilege, we explained, relates to the effective discharge of a president's powers. We thus deemed it fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. 2. Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession, as in Burr and Nixon. The danger is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. Although the president might be exposed to fewer criminal prosecutions than the range of civil damages suits that might be brought by various plaintiffs, the threat of trial, judgment, and imprisonment is a far greater deterrent. Potential criminal liability and the peculiar public opprobrium that attaches to criminal proceedings are plainly more likely to distort presidential decision-making than the potential payment of civil damages. The hesitation to execute the duties of his office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution raises unique risks to the effective functioning of government. A president inclined to take one course of action based on the public interest may instead opt for another, apprehensive that criminal penalties may befall him upon his departure from office. And if a former president's official acts are routinely subjected to scrutiny in criminal prosecutions, the independence of the executive branch may be significantly undermined. The framers' design of the presidency did not envision such counterproductive burdens on the vigor and energy of the executive. We must, however, recognize the countervailing interests at stake. Federal criminal laws seek to redress a wrong to the public as a whole, not just a wrong to the individual. There is therefore a compelling public interest in fair and effective law enforcement. The president, charged with enforcing federal criminal laws, is not above them. Chief Justice Marshall's decision in Burr and our decision in Nixon recognized the distinct interests present in criminal prosecutions. Although Burr acknowledged that the president's official papers may be privileged and publicly unavailable, it did not grant him an absolute exemption from responding to subpoenas. Nixon likewise recognized a strong protection for the president's confidential communications, a presumptive privilege, but it did not entirely exempt him from providing evidence in criminal proceedings. Taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the independence and effective functioning of the executive branch, and to enable the president to carry out his constitutional duties without undue caution. Indeed, if presumptive protection for the president is necessary to enable the effective discharge of his powers, when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. At a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. But as we explain below, the current stage of the proceedings in this case does not require us to decide whether this immunity is presumptive or absolute. Because we need not decide that question today, we do not decide it. One case in more than 2 centuries does not afford enough experience to definitively and comprehensively determine the president's scope of immunity from criminal prosecution. Section C. As for a president's unofficial acts, there is no immunity. The principles we set out in Clinton v. Jones confirm as much. When Paula Jones brought a civil lawsuit against then-President Bill Clinton for acts he allegedly committed prior to his presidency, we rejected this argument that he enjoyed temporary immunity from the lawsuit while serving as president. Although presidential immunity is required for official actions to ensure that the president's decision-making is not distorted by the threat of future litigation stemming from those actions, that concern does not support immunity for unofficial conduct. The justifying purposes of the immunity we recognized in Fitzgerald and the one we recognize today are not that the president must be immune because he is the president. Rather, they are to ensure that the president can undertake his constitutionally designated functions effectively, free from undue pressures or distortions. It is the nature of the function performed, not the identity of the actor who performs it, that informs our immunity analysis. The separation of powers does not bar a prosecution predicated on the President's unofficial acts. We've come to the end of another episode, but don't worry, next episode we will pick up right where this episode left off, beginning with part 3 of the opinion, picking up on page 16. Until then, thanks for listening to What SCOTUS Wrote Us.